In 1990, the plaintiff founded the defendant corporation with non-party Edison Price. In 1997, Price died and the plaintiff agreed to become president and CEO of the defendant. In December 1998, the plaintiff expressed an intent to resign his position, but agreed to stay on at the behest of the defendant. The parties agreed that a written contract for the plaintiff to be employed by the defendant for 1 year would be executed. It is undisputed, however, that no written agreement was ever executed, and at or about May 12, 1999, the plaintiff was terminated from his position with the defendant. He thereupon commenced this action to recover damages for breach of contract, seeking the balance of his salary for the year in question, i.e. 1999, and reimbursement for certain expenses he allegedly incurred in the course of his employment. The Supreme Court granted the defendant's motion for summary judgment and dismissed the complaint. Absent an agreement establishing a fixed duration, an employment is presumed to be a hiring at will, terminable at any time by either party for any or no cause, absent a constitutional impermissible purpose or a statutory prescription. See Loeb versus New York Telephone Company, 9X, 96, New York 2nd, 312. The plaintiff failed to raise a triable issue of fact as to the existence of a valid and enforceable oral agreement for the defendant to employ him for 1 year in opposition to the defendant establishing its prima facie entitlement to summary judgment in that issue. Furthermore, the defendant was entitled to judgment as a matter of law on the plaintiff's claim for reimbursement of certain employment-related expenses on the ground that the statute of limitations had run. Certainly, with respect to this case, the respondent was served with a petition that contained one charge of professional misconduct, which she admitted in her answer. After a hearing, the special referee sustained the charge. The petitioner now moves to confirm the special referee's report. The respondent does not oppose the petitioner's motion, but argues that the sanction imposed should be limited to a public censure. The charge alleged that the respondent engaged in conduct adversely reflecting on her fitness to practice law in violation of the Code of Professional Responsibility. On April 16, 1999, the respondent was convicted in the criminal court, Queens County, upon her plea of guilty of operating a motor vehicle under the influence of alcohol in violation of the Vehicle and Traffic Law, Section 1192, aggravated by unlicensed operation of a motor vehicle in violation of Vehicle and Traffic Law, Section 511.2. and reckless driving in violation of Vehicle and Traffic Law, Section 1212. On May 14, 1999, the respondent was sentenced to 60 days in jail, probation, and a fine. Based on the evidence adduced at the hearing, including the respondent's admissions, the charge was properly sustained by the special referee. In determining the appropriate measure of discipline to impose, the respondent asks the court to consider her previously unblemished record, the mitigating circumstances to which she testified at the hearing, the testimony of her two character witnesses, the punishment she has already endured, and her remorse and efforts to rehabilitate herself. The respondents have no prior disciplinary history. Under the totality of the circumstances, the respondent is entitled to censure for her professional misconduct.